in Montreal in January. So I know that's quite the shock to everybody. Bonjour tout le monde. J'espère que vous allez bien. I am delighted, absolutely delighted that you have joined us today. And while I'm fully mindful that it is a serious violation of decency to offer New Year's greetings after the 10th of the month, I will nevertheless risk public shame and loathing and extend to you all my very best wishes for a healthy and happy 2023. So, as mentioned, my name is George, and I will be your panel moderator today. I am currently, as mentioned, sessional lecturer at the Institute. And as you saw, I am now retired from Transat, the aviation industry, after having spent almost 32 years there. So that said, full disclosure, I have absolutely no personal and or financial links to my former employer or the industry. I'm pleased to say that my airline lobbyist hat has now been bronzed and put on permanent display in the Museum of Household Relics in my basement in my home. Nous allons procéder en anglais aujourd'hui, bien que l'Université McGill encourage l'usage du français le plus souvent possible. Malheureusement, nous ne pouvons pas vous offrir de la traduction simultanée pour notre webinaire, mais vous êtes néanmoins invités à me soumettre vos questions en français lors de notre discussion tantôt et je ferai mon mieux possible pour les traduire par la suite pour nos invités distingués. So, as mentioned by Donald, the Institute has now had a very, very well appreciated and established webinar series where to date we've had some excellent academic and dispassionate discussions on, well, we could say sober matters dealing with air and space law. But today we've decided to throw caution to the wind. And yeah, we're going to jump headfirst into an issue that has been the subject of, well, oftentimes, screaming media headlines throughout much of 2022, at least here in Canada, and most recently over the holiday period. So I think it's almost an understatement to say that we're rather topical today, and our timing for, I think, a much needed sober academic discussion in this regard is, dare I say, almost spot on perfect. So yes, we will indeed discuss the major operational challenges and disruptions that we have witnessed with the post-pandemic recovery in the global air transport industry over the past year. And we'll look at how airline consumer protection laws specifically have been responding as a result. However, and this might disappoint some people, maybe not, but there will be no Stalinist show trial today. We are not going to be pointing fingers. We are not going to be shaming or blaming. Just as I mentioned, a thoughtful and respectful discussion with our very distinguished panel of experts representing the principal stakeholders in this matter, i.e. the regulator, enforcement agency, the airline industry, and of course, the consumer. I will introduce them in just a few moments. To begin with, I would like to start with a short presentation that provides an overview of the legal frameworks as well as the issues and challenges that we will be discussing in just a few moments in order to set the table, if you will, for our exchanges and provide proper context, especially for those of you who may not be as intimately aware or involved in these matters as others. So if you just give me a second, I will now share my screen. Let me just, I hope I don't erase myself here, share screen, and here we go, share. Okay, so I hope that is now showing up like it should. Stefan Michael, you're confirming that's good. So, folks, yeah, let's talk about the application and enforcement of consumer protection laws. Are we having fun yet? So that's a bit of a rhetorical, silly question, but one that underlines the fact that, yeah, depending on your perspective, you're either having some fun or you're really, really not having some fun. And I think the young woman on the right of the screen right now can attest to that. And that, of course, is something that is quite unfortunate in what we've been seeing. So again, let's drill down a little bit in terms of what's going on. Now, I like to always start these things, at least in my class, when I talk about consumer rights. I say, listen, folks, we're not media here. God bless the media. They have their jobs, but we are people who are trying to be balanced and trying to ensure that all perspectives and the facts are always understood by everybody. So I'm going to start first and foremost by underlining, right, that, well, aviation arouses passions, and some of them positive, as Bill Gates has indicated there, as you may see on the screen, about essentially comparing aviation and what the Wright brothers created to the first World Wide Web. And then, of course, that poor soul standing by him or herself at the carousel after everybody has gone home and or onto the beach and saying, where is my quote unquote bag? And of course, that is a failure in terms of the service delivery commitment that is required here. And that's happened a lot, among other things. And it happens, unfortunately. And again, this is part of what makes aviation so passionate for the right and wrong reasons. So again, just building on what Bill Gates said, 100 years ago, we were just a planet with a lot of folks getting along on horse carriages and Model T Fords and taking about 6 days to cross, from one side of the US to the other, or whatever, Canada, or even longer by train. And of course, aviation changed the paradigm completely and made us into what is essentially a global community revolving around the sun, where you can literally go from one end of the earth to the other in the time it takes you to have maybe a couple of meals, a few drinks, a movie or two, and off you go. So this is, of course, something that we have to always stop and appreciate in terms of what the industry has done for connecting our civilization. The economics, again, I won't go through this in too much detail, but again, these are facts which have to be remembered. Now, these are 2019, 2020, but we took the last full year before the pandemic. Obviously, the pandemic completely skewed the numbers. So when we look at the numbers just before the massive disruptions of the pandemic, we see they are eye-opening in terms of the economic benefits provided by commercial civil aviation around the world. When we talk about jobs, almost 88 million, 3.5 trillion in global GDP. These are massive numbers. If aviation was a country, it would have the 17th largest GDP in the world. You see the breakdown there, GDP, employment numbers by region. And again, no region can say that aviation does not play a major part in their economic development and connectivity. However, as mentioned, starting in 2020, and this gives you an idea of the challenges, huge economic challenges, financial challenges, and the rest. And of course, the basic impacts to people and their livelihoods from the pandemic. When we look at these are 2020 numbers, catastrophic decline, obviously, in economic output. 46 million people lost their livelihoods, 2.3 billion fewer passengers. I mean, these are all completely never seen before. As we all know, we won't dwell on that. This is well known by now, but the emphasis is on an industry that was clearly in crisis and it was clearly dealt the biggest blow in its history, and obviously had to struggle to get back, as we saw over the last year. So these were not negligible impacts. Again, we're not just about numbers. We are people. We are human beings. So we are connecting, and aviation is connecting the world. Aviation does support, like we said, jobs, worldwide economic growth, prosperity, very much so today in developing countries, supports trade and commerce, helps pay for a lot of public infrastructure out there that we use to support greater economic development. In Canada, for example, aviation and its customers pays for almost all of aviation infrastructure, airports, air traffic control services, etc. Not one dime from the public purse. It provides links for remote communities, huge countries like ours, that's a big one. Delivery of humanitarian aid, food, etc. And it drives a lot, and this is important, right, in terms of the climate change narrative and the sustainable, long-term environmental sustainable challenges, a lot of new technologies, and aviation is at the forefront of working to develop cleaner technologies such as sustainable alternative fuels, which will lead into huge reductions in carbon footprints and carbon emissions. Again, in pictures, right? What we do, opportunities provided, This is all something that I know the person waiting for that bag at the carousel doesn't want to hear, but again, important for a balanced discussion, I think. Almost 9,000 planes in the sky at any one moment, depending on the time of day and where you are in the world. That's a lot of traffic. Got the aeronautical symphony in the sky. And we do it every day almost, well, I'm sorry, guys, not we, the industry does it every day almost without issue. But then, of course, we do know problems do arise from time to time. We remember always that aviation, commercial airlines don't operate in a vacuum. They must rely on other service providers to get that service delivery to the consumer and get them, him or her or them, where they're going. And of course, we know that that's airport operations, that's air traffic control, keeping the sky safe, that's customs immigration folks, keeping our borders safe, and of course, security, keeping folks safe in the air and on the ground. These are third-party suppliers, right? The most part to commercial airlines, and clearly commercial airlines are highly dependent on their performance to be able to deliver their promised service to the customer. And guess what? Again, let's be contextual here, especially in Canada. For those of you who are not in Canada, we had a tree fall on the train on a train, a VIA Rail train during the holidays. Total chaos in the railroads. One train, and by the way, there's no consumer protection law for railroad passengers, but that's another issue, guys. We won't dwell on that fact too much today. But I think it's important, again, that we step back and remember that, yes, it's a very complex business, commercial aviation, and we are subject to very prescriptive laws. But again, this is not something that is done, I think, in a uniform way across all forms of transportation modes. Remember those 9,000 planes in the sky. You have more people getting killed on roads around the world in cars, trucks, buses, whatever, in one morning than you do an entire year. And I would say significantly fewer than an entire year in commercial aviation. These numbers are comparing to United States driving fatalities. That's very unfortunate. But remember, this is a complex business which gets done almost seamlessly in terms of safety for all those who are traveling. And that's something that has to stay always as a top priority. Air Canada is nice enough to hopefully give me the right to show a little map of one of their networks here. This is their North American network, with all due respect, Jared, to WestJet. This is their a snapshot of North American network. Why do I have this here? I'm not doing marketing or sales for Air Canada, but I am reminding folks that the reason you can go from Sudbury to Athens fairly quickly, fairly seamlessly, because of complex networks like these. Where you have, of course, hub and spoke connecting services in and out. And yes, when you start going south in terms, well, not literally, but metaphorically in terms of weather conditions, the rest of that stuff in one side of the country, you'll feel it on the other side of the country, especially in a huge country like Canada, or of course in the United States. It's the same thing. And that's to be able to maximize routes, frequencies, and offers to the customer, the consumer. But then this happens. And again, this morning, I was making an off-ad remark, but yeah, in all fairness, snow in winter in Canada should not be a shock to anyone, certainly not airlines. But again, we all know that sometimes it does have an effect, and we have to ask ourselves, how do we best maybe prepare for that? And how, again, do we make sure that our laws understand that, yeah, there are challenges here. I dare say you don't see this at Tunis Airport in Tunisia very often, right? To 2 feet or 30 centimeters of snow. So again, everybody has their respective challenges, but we have to make sure that things make sense here in terms of the realities. And of course, when it does happen, this happens, and this is unacceptable. Okay, let's be clear, folks. Yes, nobody wants to see this, but how do we best manage these things? They will happen. It's a question of managing, in my opinion, properly, and of course in conformity with applicable laws. We'll have that discussion. I certainly won't go into detail at this point. Let's just understand as well that in Canada, before the pandemic, you had 82 million passenger embarkations, right? Number of times a person stepped on an aircraft. But when we look at the CTA's annual reports here in terms of consumer formal consumer complaints, right? You're looking at, for example, the last year before the pandemic, you had 20,000 complaints. That in and of itself is not an insignificant number, but compared to 82 million employments, it's 0.024%, right, of total employments, if my mathematics and my arithmetic is holding here this morning. Now, again, one complaint is too many, but the other thing we need to do, and the other side of the coin here, is the trend, right? Because as of 2015, we've been doubling the number of complaints year over year, practically. And I dare say that those numbers, and we'll discuss that, have gone up significantly over the last couple of years. And Tom from the CTA, who I'll introduce in a few minutes, will be telling us about that. So there we go. When that happens, we have to start going to the passenger rights framework. And in Canada, just in time for the pandemic in 2019, we adopted the Air Passenger Protection Regulations. This will be the focus of our discussion today. And just as a very quick overview for some folks who may not be familiar, other than what you read in the headlines, the APPRs essentially, first and foremost, require clarity and precision in terms and conditions of carriage, communication of those to the customer, mandatory communications during disruptions, reasons for delay, schedule updates. You've seen those, I'm sure, when you fly now. Carrier has your cell number. It'll give you an update as to your delay and reasons, etc. Minimum compensation, passenger treatment standards are provided in the event, or prescribed in the event of delays, cancellations, and overbookings, tarmac delays, lost, damaged bags. And in Canada, we also provide, we won't talk about that today, requirements to have children under 14 seated near their parents, and specific requirements in transportation of musical instruments. Yes, indeed, the musician lobby is alive and well here in Canada, so good to see that. Now, the compensation requirements above for delays, cancellations, and this will be a topic with our discussion today, for delays and cancellations will vary depending on the circumstances that led to the disruption, either within the carrier's control, within its control, but for flight safety purposes, talk about that in a second, or completely beyond its control. And that generally is understood to be weather, external strikes, air traffic control strikes, that sort of stuff. Very quickly, you have the amounts, the compensation amounts, where they apply, depending on large or small carriers. And of course, denied boarding is significantly higher, given the nature of the disruption. The passenger treatment standards, fairly standard, to meals, refreshments, vouchers after a certain number of hours, 2 hours, access to communications, hotel accommodations in the event of overnight delays, and rerouting, alternative bookings, alternative travel arrangements in various circumstances. Again, we won't go into that in detail today, or refunds of unused tickets. And again, as of 2022, by the way, refunds for unused tickets have only been mandatory under federal law, meaning the APPRs, in the event of external or extraordinary circumstances, meaning beyond the carrier's control. So, we'll talk a little bit about that. During the pandemic, there was an issue about people not being able to get refunds and only getting travel vouchers. But it's important to understand that that was only mandatory in most cases because of the pandemic and the border closures. In those sorts of circumstances, now it has become mandatory only as of September 2022. It was not mandatory at the time. For safety purposes, like I said, these are the definitions in the cars. No, I'm sorry, not the cars, the APPR. So again, I won't go into detail, but it has to be unforeseen. It has to be clearly something directly that affects the safety of passengers on board. It has to be something made in virtue of the safety requirements and the authority invested in the pilot and command, or pursuant to a safety management system, or the cars. And again, it has to be unforeseen. Can't be something that was already known or previous maintenance check or whatever, and then all of a sudden it blew up in your face or whatever, and boom, you ground the aircraft for 6 hours. So again, this has to be this is how we define the safety exemptions. And I think we all agree. By the way, this is a real picture, right? For folks who are not aware, that was a United Airlines 777 about 4 years ago, where the engine essentially blew up in flight. You don't want to see that looking out your window unless you've had at least 3 or 4 gin and tonics, just saying. But we all agree have never heard anybody to say to me, well, flight safety, I think they're getting a little uppity with that stuff, and we need to bring them down a little bit there. And we don't want to really keep emphasizing that. Everybody wants to enhance flight safety. The question is there something that may be potentially undermining it, inadvertently or not? Given that Canada has addressed it specifically, is that exemption potentially being used to avoid legitimate compensation, which is not meaning compensation due because it was not a legitimate safety issue? This is currently something that the CTA and the courts here in Canada, which I think we might chat about a little later on, are currently addressing. The APPR was modeled on EU 261. EU 261 is the granddaddy of them all, adopted in 2004 in terms of integrated passenger rights frameworks. And again, I won't go into detail right now, but clearly same types of compensation requirements, except that EU 261 did not provide specifically delay compensation. It was only done later on through case law. EU 261 does not specifically exempt payment of compensation in the event of what can be considered disruptions due to safety issues, mechanical technical failures that affect safety. This was developed later on through jurisprudence in the EU. As we'll see here, the jurisprudence hasn't been very uniformly applied because we talk about what may or may not be inherent in the exercise of the activity of an air carrier as being covered or not through the exemption. This, as you may have guessed, is somebody that ran into some big birds in flight. At the time, the EU Advocate General said, well, no, that's inherent in the exercise of an air carrier, so you're responsible for paying compensation for the delays required. Thankfully, because of the uproar, that was reversed. But the problem with this is you have a very confusing framework in terms of trying to deal with what is essentially a pretty ambiguous standard here, and whether or not that may be inadvertently undermining flight safety or not, because of pressures we put on carriers to avoid potentially paying very expensive compensation claims when they're doing legitimate repairs for safety purposes. Minister Omar Gabra here in Canada, Transport Minister, has said, as a result of the latest troubles, changes are coming. So stand by. We don't have any news yet as to what those will exactly look like. But again, I think that we're probably going to see some major changes shortly on this. I'm going to just now, that's the end of that. I'm just going to stop that share. So let me just load something on here. Excuse me, folks. I made a bit of a mistake here. Boo-boo. Here we go. Okay. So now then, I hope that was somewhat informative. I'm now going to proceed to introduce our distinguished guests and ask them thereafter to provide each a 5-minute opening statement on our subject matter of the day. And then, of course, we'll proceed thereafter to the panel discussion and Q&A. So let me start, as I quickly mentioned before, with Tom Oomen. Tom has been with the Canadian Transportation Agency since 2019. He currently serves as the CTA's Director General of Analysis and Outreach and is responsible for regulatory development and communications. Prior to joining the CTA, he served for over 30 years with various other federal government departments, mainly in the areas of trade and transportation. He holds bachelor's degrees in science from McGill University and in engineering from the University of Montreal, as well as a master's in public administration from Queen's University. Tom, welcome. Over to you.
Thanks very much, George. Let me just check that you can actually hear me.
We're good.
Excellent, excellent. So just as a reminder to everyone, the Canadian Transportation Agency is an independent regulatory and quasi-judicial tribunal. It operates within the legislative framework provided by Parliament. Let me begin my comments with some context. Before 2019, each airline spelled out its obligations to passengers in their contract with the passengers, the airline tariff, which a passenger essentially accepts as part of the contract when purchasing an airline ticket. Tariffs still exist today, of course, but before 2019, each airline had its own set of obligations to passengers for flight disruptions. And while it is true that the agency had issued a number of decisions before 2019 that ruled on the content of specific cases, there was no overarching common set of consumer protection requirements that applied to all airlines. That changed in 2019 when regulations came into force in Canada, the Air Passenger Protection Regulations, or APPR, that for the first time established minimum consumer protection requirements that all airlines had to follow. The agency made these regulations following changes to legislation by Parliament the previous year that authorized the agency to make the regulations and that established 3 categories of flight disruptions with different passenger entitlements depending on the degree of control that an airline exercised over the flight disruptions. So flight disruptions could be categorized as either within airline control but required for safety, or outside airline control, as I said, with different passenger entitlements depending on the category of flight disruption. Now, what we have seen since the regulations came into force in 2019 is that passengers have indeed availed themselves of the regulations to file complaints against airlines for not respecting the regulations. The agency has received more complaints than it has been able to process in a given period, and we currently have a backlog of about 34,000 complaints. Now, our experience has been that a vast majority of these complaints are resolved informally through a facilitation process, which only takes an average of 20 business days to close once an agency facilitator begins the process. Also, I would mention, in order to help passengers who have filed complaints with the agency, we have recently added a new application to our website, Case Status Update, which allows every complainant to know where they stand in the queue and what the next steps are in resolving their dispute with the airline. We have also provided consumer-friendly guides that can be easily read and navigated on a smartphone, as well as providing information on what passengers are entitled to and how to file a complaint using easy-to-follow web pages with drop-down menus to make it easy to follow the process. In the meantime, as is the case with any new regulation, the agency continues to issue decisions on complaints and to interpret the regulations. For example, the agency has ruled on the level of detail that an airline should provide after a flight to explain a flight disruption. Generally, the agency has said that an airline should provide information in sufficient detail for passengers to understand the reason given by the airline and how this reason caused the flight disruption. And in the case of a request by a passenger for compensation, the airline must provide sufficient information for the passengers to decide whether they wish to challenge the carrier's rejection of their request. The agency has also interpreted the regulations to mean that flight disruptions due to crew shortages would normally be considered within airline control because airlines control their human resources, hiring, training, and scheduling processes, and are expected to have contingency plans in place to deal with crew shortages. And of course, further interpretation of the new regulations will continue to be provided as the agency issues more decisions on APPR complaints. And George, I think I will stop there.
Great. Thank you, Tom. Appreciate that. Okay, I'm going to move next to Maître Sylvie de Bellefeuille. Maître de Bellefeuille has been a lawyer since 1998 and holds a Bachelor of Laws degree as well as a certificate in criminology from the University de Montréal. Since the beginning of her career, Maître de Bellefeuille has worked mainly with not-for-profit advocacy groups. In 2010, she joined Option Consommateur, where she offers budget consultations, presents workshops, and answers consumers' questions about their rights, among other tasks. She also manages most of the class action suits undertaken by Option Consommateur and participates in the association's numerous representations in this regard. Maître de Bellefeuille, bienvenue. The floor is yours.
Thank you very much. Greetings to all. So to begin, I would like to thank you, George, for inviting me and also McGill University to provide me with the opportunity. So for those of you who don't know Option Consommateur, we're a not-for-profit organization whose mission is to inform consumers and defend their rights. We receive each year thousands of demands from consumers who are having problems with all kinds of merchants, including the travel agent industry, and we give them legal information so that they can assert their rights. Since since the beginning of the pandemic, the troubles suffered by passengers showed us that there are gaps in the regulations and that were basically meant to protect them. Hence, changes were made recently to the APPR to clarify the rights for passengers to be reimbursed when the disturbance is out of the air carrier's control. Despite these recent changes, the chaos in Canadian airports in the summer and during the holidays showed us two things. First, customer satisfaction is clearly not the priority of air carriers. And second, the actual regulations do not provide adequate protection to consumers. As presented by George in his introduction, in case of a flight disturbance, the air carrier's level of liability depends on its level of control on the situation and whether the disturbance is caused by safety issues or not. This is logic in theory, but practically it raises a lot of problems. And I believe that there are 34,000 and more complaints waiting at the CTA, which basically is the tip of the iceberg, also shows that there's a problem there. It is the passenger's burden to file a claim to the carrier when there's a flight disturbance. And to do so, the passenger must rely on the information that is provided by the air carriers. The more control the carrier has over the situation, the higher the compensation. Needless to say that the carriers are clearly in conflict of interest here. A good example of this conflict of interest occurred last summer when flights were canceled due to staff shortage. Many passengers were told that it was out of carrier's control because of the pandemic and were denied compensation. Others were told that it was a safety issue. Now, we've just heard from Tom that CTA did rule that, well, staff shortage is supposed to be within the air carrier's control. If a passenger disagrees with the decision of the air carrier, it's again his responsibility to file a complaint to the CTA and again have the burden to prove that the carrier did not apply the regulation properly. Moreover, passengers can only rely on the information provided by the air carrier who decide whether or not they will file a claim. It's clearly an unfair battle. It's basically David against Goliath, and here you can picture Goliath as a titan. This burden of proof should be reversed in our opinion, and we believe also that passengers should receive automatically what they are owed and not have to claim for it. There's also a problem with the definition of safety problems. This reason can unfortunately be easily used as an excuse by air carriers to diminish what they are owed to passengers in case of disruption. For most passengers, almost anything can seem to have an impact on safety. And of course, who doesn't want to travel safely? Consumers do not know the difference between the safety problem and other types of disruption. And we have seen it again this summer for the situation we've just mentioned. So for us, it is clear that the difference between what's within the air carrier's control and within the carrier's control but necessary for safety purposes is a difference that maybe we should not apply and see and maybe take more apply the similar rules that are applied in the European system. Also, as I said earlier, there was amendment to the APPR for delays or canceled flights that were caused for reasons outside of the air carrier. But the problem when it comes to refund is that it only applies when the passenger cannot be rebooked within a 48-hour period. Now, it may be okay for some passengers, but for some others, it can bring the travel simply. Can picture, for example, a situation when a person is traveling for a cruise and the person simply missed the boat. There's no point into traveling in those kind of situations. So what we believe is that in those kind of situations, passengers should be allowed to refund in those kind of situations. Lastly, the explosion of complaints filed before the CTA is clearly a sign that passengers believe that the air carriers do not comply with the regulation. And we also know that only a minority of passengers will go through all of the process in order to get what they are entitled to. At the end, if air carriers are forced to pay only a minority of their clients, they're still winning at the lottery of compensation. So we think that the situation should be changed, and that the CTA should have and use enough their powers in order to force the carriers to respect all of their clients. And for that, of course, the CTA will need to have sharper teeth and enough manpower to do so. Thank you very much.
Thank you very much, Sylvie. Was very clear on many levels. So now I'm going to invite James Wilshire. James to join the discussion. James has been IATA's Assistant Director of External Affairs since January 2019. As such, he is the global policy lead for consumer issues and is responsible for developing and coordinating industry positions on passenger rights issues. He was also at the forefront of developing IATA's policy response to the coronavirus pandemic, including its engagements with UN agencies such as the ICAO and WHO. James is an economist by training, and prior to joining IATA in 2013, he worked for the UK Government Economic Service and for its civil aviation regulator. He holds a bachelor's degree in economics with Hispanic studies from the University of Nottingham. He speaks absolutely perfect Castilian Spanish, and also holds a master's degree in international relations from the Graduate Institute in Geneva. James, bienvenidos, over to you, please. Go ahead.
Thank you very much, George. And unfortunately, obviously, the Spanish is not so useful in Montreal, but I will do my best in good old English. So you give me 5 minutes, so I'd like to make 5 points, I think. The first of those is, in your excellent presentation, you talked a lot about the connectivity and the choice. You didn't talk about value. And I think it's something that is really important to alight on here, that I think the airline industry has got a phenomenal consumer-facing value proposition in terms of all that connectivity, the choice between airlines en route and off routes, and the fact that over the long run, in real terms, the cost of traveling by air is consistently trended downwards. And, you know, that's a very, very strong proposition for the consumer. They get choice and they get value. And that's important when we're talking about frameworks such as the APPRs or EU 261 that have very costly compensation attached to them, because somebody's got to pay for that compensation. And before I get there, maybe if I just alight the second point on what do consumers actually want? Do consumers really want compensation? Have they been calling out for it? And one touch point and insight into this is research the European Commission called by a consultancy, Steer Davis Gleave, just before the pandemic in reviewing EU 261. And it asked passengers essentially what they wanted in the event of disruption. And the findings were very clear. The first thing that consumers want is clear information about what's happening, what's happened, and what's going to happen. The second thing that they want is they want, in most cases, to continue their travel and to get to their destination with the minimum of disruption. And that's obviously the part of EU 261 that talks to rerouting, and that's also copied over in the APPRs. And compensation only comes third. So it's not the thing that the majority of consumers are most interested about. And I think that's important to bear in mind. Then thirdly, if we look at this from the industry perspective, to what extent, are airlines motivated to avoid disruption? Well, I would say very strongly. And George, in your presentation, you gave the quote about the "where's my checked bag" when it's been mishandled. But if we think about this from an airline perspective, it is so much more expensive to repatriate to a passenger a bag that has gone astray. You need to firstly find the bag wherever it is. You need to fly it from the station where it is to the destination that consumer is at. And it may not be the destination that the consumer had traveled to. They may have gone on beyond there and wanted at a third point. So you need to fly the bag to that point, and then you need to hire a courier to get that to the passenger's location. That is much more expensive than delivering it to the bag and to the luggage belt in a timely manner. And there's that example of the baggage, but it goes for delays. They cost huge amount in terms of having crew and aircraft in the wrong place. All that to say, airlines have a huge incentive to operate the schedule as planned, and disruption costs money, and airlines don't want disruption. So here we get to the question: if we understand what we think consumers want, we understand the industry incentives, what's the role of regulation? And I would posit that the role of good regulation should be to change performance. But that's not what EU 261 does, and it's not what the passenger protection regulations in Canada do. And we can see that because if we compare, and I have historical data for Europe, so I'll talk about Europe here, but I'd be unsurprised if the same thing held for Canada. We compared delay performance, on-time performance, and cancellations in the European Union over a period of time with the same statistics for Australia, a country that doesn't have a formal air passenger protection regulation. And there is no difference in delays, and there is no difference in cancellations. So we get into the situation where the regulation isn't actually impacting performance. It's merely taking money from one pocket and putting it into another. And there are reasons for that, and I'm sure we'll get onto it a little bit more in detail, but it does come down to this issue of control and the complexity of the supply chain that you talked to, George. The final thing here is I'd just like to actually go back to what ICAO says on this, and it has core principles on consumer protection, and of course it has also the Montreal Convention 99. But as we're having a Canada-based discussion, we should also talk about ICAO, as Montreal is also the home of ICAO. And if we look at those core principles on consumer protection, it talks of achieving a balance between the legitimate interests of consumers and the need to protect consumer interests and industry competitiveness. And I would posit that the regulations that we're seeing, like the APPRs and EU 261, don't achieve that balance. And if we look at the cost benefit and analysis that accompanied the air passenger protection regulations, they show that. What that cost benefit shows is that the APPRs are a pure transfer from airlines to passengers, not changing outcomes. It's not balancing interests. It is just robbing Peter to pay Paul. And I don't think that should be the objective of good regulation. We can get that into a little bit more detail, but I'll close for now, George. Thanks.
Okay, thank you, James. Again, I'm going to be the neutral academic here, and I will say no comment for the time being, but thank you, James. Very, very clear and very eloquent. Okay, last but not least, Jared Mikosh-Gurki. Jared is Director of Government Relations and Regulatory Affairs at WestJet, and for its subsidiaries, WestJet Encore and Swoop. He manages the WestJet Group's relations with the federal and provincial governments and leads the regulatory affairs team responsible for facilitation, accessibility, passenger rights, and aviation policy matters. Jared studied aviation and airline management at the University of North Dakota, as well as marketing management at Mount Royal College in Calgary, and he sits on the NACC's executive committee. So Jared is our guy in the airline, day-to-day airline trenches, and today we'll ask him to put on his helmet and get going with his opening statement. So Jared, thanks for joining us. The floor is yours.
Good morning, George. Good morning, everyone. Thank you very much, George, for that introduction. As George said, my name is Jared McCosh-Gerke. I am responsible for government relations and regulatory affairs at the WestJet Group of companies. And this does include all of our regulatory obligations, including the air passenger protection regulations. For a bit of background, WestJet started in 1996 with just a handful of 3 aircraft and flew primarily in Western Canada. Since then, in the last 27 years, we've proudly grown to be an airline of over more than 180 aircraft. We have over 14,000 incredible and dedicated employees that we refer to as WestJetters, and we fly to more than 110 destinations in 24 countries. In this time, we have cut airfares in half and increased the flying population by more than 50%, something that we are incredibly proud of. WestJet is first and foremost a transportation organization that is focused on customer service. We've continually been recognized for our customer service and our dedication to our guests, and that continues to drive us today. We take our regulatory obligations very seriously and have always been known to have a collaborative and respectful relationship with all regulators. This is similarly true when it comes to the air passenger protection regulations. We are actively engaged in the development of these regulations and every consultation of the regulations since. While the regulations are written in a simple manner, they do not consider the extreme and incredible complexity of our industry. And similarly, they do not consider the implications of other difficult regulations, such as the implementation of new flight and duty regulations that impose new restrictions on rest and duty limitations that reduce flexibility for air carriers. As was considered when these regulations were created and implemented, safety needs to remain sacred. We must be careful to ensure that any regulatory regime does not put profits, or in this case, risk of losses, ahead of any safety situation as a primary motivation to be able to operate aircraft on time. We live in a very, very large country where air travel is an absolute necessity in order to be able to travel. There are no other alternative travel methods that are similarly effective as there are in Europe. Our population is 1/10 the size, yet many multiples larger in geographical area. Similarly, we operate under very different and extreme weather conditions. Where Europe sees no more than 20 days of snowfall, Canada sees on average between 55 and 115 days of snowfall. We can't compare apples to oranges. Lastly, as it pertains to our obligations with the APPRs, we resolve over 99% of claims that come to WestJet directly. And we resolve these in-house without any involvement from the CTA. There is a significant amount of misinformation that is spread to the public, and frankly, factually incorrect information that drives an increase in claims and complaints to the CTA. While there is a concern of the 30,000 complaints to the CTA, this is to be expected with the introduction of a regime like this and some of the information that is spread to passengers. I would remind everyone that over 50 million people fly in Canada every year. 30,000 complaints amounts to 0.0006% of travelers, which is an incredibly small number. And as it pertains to WestJet specifically, we receive more claims than that on a monthly basis. Lastly, bad events should not result in bad policy, particularly when we are looking at what occurred this summer and this winter. While we can all continually improve on our roles, we shouldn't swing the pendulum so massively in a responsive manner that it ends up harming consumers with higher airfares and reduced competition. Thank you, George, and I look forward to the discussion.
Great. Thank you very much, Jared. Okay, then. So we can now move to our panel open discussion and Q&A. So if I may start the ball rolling on Q&A, let me go back to Tom Oomen. Tom, as I mentioned quickly during my presentation, the APPRs were recently amended in September of 2022. We saw that during the pandemic, there was a virtual collapse, of course, in national and global airline schedules and networks, resulting from the shuttering of borders around the world very suddenly. And as a result, alternative booking, right, and rerouting were very, very hard to deliver to consumers who were affected, because in any event, nobody was traveling anywhere. Borders were shutting down to visitors, et cetera, et cetera. As a result, many people wanted their money back and demanded refunds. And as we know, in Canada, carriers resorted to, in a large part, not all, to issuing vouchers or travel credits that could be used in your future refunds. This created a major backlash, as you, of course, are intimately aware, and the CTA went to work to address a lot of those issues, including what was announced and what was enacted in last September. Please go through a little bit about what happened there, how the CTA dealt with the matter, including the statement that was put out at the time, as well as take us through a little bit about the changes that we saw come into effect on refunds in such extraordinary circumstances last September.
Thanks, George. So what I can say, as you said, shortly after, after the regulations came into force in 2019, we had the COVID pandemic. And in that we understood there was an obvious gap in our regulations. The 2019 regulations only required refunds for flight disruptions within airline control or within airline control, but required for safety. During the pandemic, many flights were canceled, and it was often impossible to reschedule passengers because of the lack of flights. So amended regulations were brought into force in September 2022 to ensure that even if a flight disruption were outside airline control, airlines would have to offer a refund if they couldn't reschedule a passenger within 48 hours. So there was a significant amendment to the regulations in 2022, even though the regulations themselves only came into force in 2019. Thank you.
Okay, thank you, Tom. By the way, panel, if you have any interventions or any comments you'd like to make on any of the aforementioned statements, opening statements, or answers to some of the Q&A, feel free. Just throw up your little hand there, button function, and happy to continue the discussion along, because this is the whole point, guys. I want to make sure everybody has a chance. I am trying to follow at the same time the online chat. I see that it is quite populated with quite a few comments, and I'm looking for a few questions, but I'll come back to that in a few seconds, because I'd like to see if we can put some questions to the floor. But let me continue the ball rolling with some questions, at least from my end as moderator. And again, I don't want to have a monopoly on that. But let me turn to you again, Jared, if I may. And as you know, the airlines have been accused of pointing fingers all around at everyone, except, including Mother Nature and the weather, all that sort of stuff, with respect to a lot of the disruptions, systemic disruptions we saw, especially last summer, with the system not being able to keep up, if you will, with the sudden increase in passenger volume after the pandemic. And of course, massive weather-related issues last holiday season. We've seen, as you mentioned, it's a highly integrated system. Tell us a little bit about what you believe governments and your air transport system partners can do to help mitigate a lot of the service delivery issues and customer impacts, consumer impacts, and disruptions in the future. And if I may channel my inner Oprah. Tell me what airlines can do maybe a little bit better in the future.
Your inner Oprah, I like that, George. Listen, first off, I'll never claim that we are perfect. I will never claim that we don't have opportunities to improve. We're an incredibly dynamic business in an incredibly dynamic and growing sector, and seeking improvements and opportunities to do better by our guests and in terms of the service that we deliver is an absolute cornerstone of our business. And frankly, you know, an airline or an airline that cancels significant amounts of their flights is not one that we intend to be. It's not one that we know our guests want. We intend to be able to operate as on time and as regularly as we possibly can, notwithstanding any of the challenges or external implications that get thrown at us. So perhaps I'll start with the last part of your question first, channeling your inner Oprah and what we can do better. What we've learned over the last year is that we have to improve, particularly on how we can reunite people with our baggage. So we saw that both in the summer and in the winter, and that's been highlighted for us internally as an opportunity to be able to improve. The one thing I always like to say about baggage is they're much more difficult to be able to get to their final destination. They take more time and they take more effort. They can't put their hand up and tell us where they need to be, and they can't tell us if they're worried about missing their flight. We have to go through them one by one. Often, you know, it's the same black suitcase multiplied by a significant amount that we see. So this is something that's top of mind for us as we look at operational areas that we can improve on. Second is communication. So we do already communicate an enormous amount with our guests on a range of issues, all the way through the booking process, through their travel journey, post-flight, and then obviously we have our obligations under the APPRs, and then we communicate in a whole host of other reasons. So there's no shortage of communication that we get to our guests. But I think that what we really need to drill down on is where we can do better, and specifically what our guests are looking for and what do they want to know. That's not the same for every guest. Every disruption is not the same for every passenger. The circumstances are entirely different. So it's very individualized, and that's one thing that we're also looking at. As for government and service providers, as was seen over the winter, there were enormous delays at security, or I guess this is back to the summer. Winter was good by CATSA, but in the summer, there were some enormous delays at security by CATSA, which is a crown corporation of the Canadian government. And similarly, for people that were arriving in Canada, we had instances where individuals were held on board waiting to deplane for hours at a time at the gate, waiting for customs, which again is a government-run entity. This winter, we saw a catastrophic baggage failure in Toronto that took down the baggage belt for over 2 days, delaying thousands of bags. In Vancouver, we saw a full gridlock of the airport where capacity was not managed properly during a winter weather storm that has not been seen ever, frankly, and I do mean that. They got more snow there than they've had in 168 years of tracking. So since they've ever started tracking snow, they've never seen larger amounts. And that the infrastructure related to snow removal and de-icing really wasn't able to manage the volume. That meant that they ran out of gates, they ran out of parking space, and they couldn't get critical equipment out to the airfield. Air carriers really are the only regulated entity. And that's where we see issue right now. What we're looking for is for these other entities to have a shared responsibility for their failures, particularly as we're looking at opportunities to improve for consumers. And ultimately, we're looking for a system that better supports them. Given the complexity and the interconnectedness of our sector, we ultimately need everyone to be able to level up, not just air carriers, but everybody that's involved in the system, so that we can provide something better for consumers.
Great. Thank you, Jared. Are there any comments to that? Sylvie, I'm sort of looking at you here. You've been kind of quiet. I'm hoping I can count on you for a little bit of maybe comment or pushback on that. If you don't, if you have some suggestions, you're on mute, Sylvie, so if you want.
Yes. Well, when it comes to baggage, I do know that there was not just the fault. There was different entities involved in the situation, so that I do know about. And we surprisingly, we did not receive many complaints about luggages. So I guess most of the air carriers did their job right into either informing or providing help to consumers, which is a good thing. And then if there's a backlash economically and you have to sue other people, that's something else. But we didn't seem to receive too many. So I guess on that level, the air carriers seem to have done their job correctly for most of them, for most people. So that's one thing. Should other entities be also regulated? That's a good question. I'm not against that, of course. If it's to get consumers get better service, why not? Then I think it's James who mentioned it, that compensation ultimately have a cost. So of course, if there's more liability on air carriers, usually that will probably have an effect on the price of plane tickets that will be sold. So that I am also aware of. And so basically it's not always the same for everybody. And from what I've seen, when people file complaints, most of the time that applies to air carriers, but it applies to any kind of merchant. People don't like to file claims. People do not like to file any kind of lawsuit because they feel it's complicated, it is stressful, and ultimately it's not what people want. They just want to be respected. And a lot of times when people do file complaints, usually it's because they have the feeling that they have not been treated fairly. That also is a big issue there for most consumers. I think it talks a lot about consumer service, customer service to some companies as well. So I think it's something that could be, and I'm not pointing any carriers in particular, but we do have more complaints from some air carriers than other. I'm not going to name anybody here, but customer service seems also to be a problem in some cases as well, and that could avoid a lot of complaints at any levels, I would say.
Okay, thank you. Any other comments on that, perhaps, James? No.
George, just one thing,
Yes, sure,
one quick intervention on that, just related to the complaints. I think Tom hit on this in his opening remarks too, but the level of, or the number of complaints that are at the CTA are also not all APPR related. They're not related all to claims. They're related to a whole host of issues that passengers now feel like that is a channel that offers them the opportunity to complain to. And I think there's an important distinction there, particularly as we're talking about APPR. And I'll go back to, the volume of resolutions that we have in-house is it's absolutely significant and something that we're relatively proud of. Again, we always have the opportunity for improvement, but the complaint volume that sits in front of the CTA, unfortunately, is it's effectively acted as a open complaint line for a whole host of issues, and of which we continue to work with the CTA on for any resolution, but they're not all APPR related.
Okay, thank you. James, over to you again. You raised some very interesting points, I believe it was in your opening, about, we've had a discussion here, we've seen in media suggestions that, well, the problem is penalties are not being applied. Right? The problem is they're too easily affordable. The business case is simple, screw up, pay the penalty, move on, make your money. And obviously the suggestion is that those need to be much more aggressively enforced and increased to make them hurt, right? And as such, alter behavior as a result, and ostensibly result in better performance. You have said that is not necessarily the case, and we've seen that in other jurisdictions. And that's why I've got you here, James. You're our guy who comes into our discussion here in Canada, bearing some interesting tidbits about what has gone on elsewhere. And you've suggested that there is no necessarily correlation between prescriptive passenger rights regimes and better performance. In fact, quite potentially the opposite. And again, also the issue of no free lunch. Right. So obviously somebody has to pay. And we saw the gargantuan losses that the industry experienced during the pandemic. So in brief, we've been asked here from the floor, from one of our attendees, where can we perhaps find more studies or data on this issue that you've raised here about the correlation, or not necessarily a correlation between prescriptive passenger rights regimes and better performance, better consumer satisfaction, that sort of stuff, because that is a big one. And it'd probably be very interesting for us here in Canada to look at that. I suspect the minister who's got his staff, over in Ottawa, probably looking at ways to try to address some of these issues, might be interested in knowing what's out there in terms of an empirical or discussion or analysis on the issues you've raised here. So can you perhaps go into a little bit more detail about that and what you know, and maybe what you think we should be?
Well, I think maybe I'll sort of jump off on something that Jared said, which is the point about the shared responsibility. And I think that's one of the reasons why you don't see the correlation, is because it's about the whole system that leads to the disruption, yet the regulation only affects one player. And again, as Jared highlighted, that's private sector entities and public sector entities that play a role in that passenger experience. So I think that, maybe that's the why. I mean, maybe then to the cost and the lack of free lunch. I saw a question in the commentary about if everything was paid, what would that cost? And I haven't done the maths for Canada, but it was done. The maths was done for the European Union just before the pandemic, and that was quite insightful, because it basically said in 2011, which is sort of the previous review point before the review that was unfortunately halted because of COVID. EU 261 cost airlines 1.8 billion euro in 2011, and that by 2018 that had risen to 5.3 billion euros, and that if every single claim that was valid was filed and then paid out, the liability would have been nearly 10 billion euros. 10 billion euros. And it's a colossal amount, and it's significantly in excess of the profit per passenger that airlines were making globally around that time, and particularly in Europe. But if we think that, to this point, that just make airlines pay and that will focus minds. Before COVID, because obviously you talked of the losses that airlines made during COVID. Before COVID, which is some of the best years in terms of financial performance at a global level the industry had ever had, we were looking at about 10 US dollars of profit per post-tax per passenger. A little bit more in North America, a little bit less in other parts of the world, but that's the kind of our ballpark figure. And we're talking compensation for a 3 to 6 hour delays under the APPRs of 400 Canadian. It's multiples. You've got a 300 passenger flight that's delayed by 3 to 6 hours. That's 120,000 Canadian in compensation right there. These are not small amounts when we're talking on that same flight of profit on that flight, post-tax of around 3,000. So I think that the financial incentives are clear, and then we add in all the other costs of disruption. So we can look at preparing more data on that correlation between compensation delays for sure. But the financial incentives are already there. You don't need the compensation to do that. And Jared talked about that very eloquently. And it's this issue of accountability along the supply chain. And I think that's why you don't see the policy lever leading to improved performance.
Okay, thank you for that. And I'm going to do a mea culpa here, because clearly we probably should have had somebody from one of the main service providers also discussing some of their challenges, ideally airports. So I do apologize for that. But, maybe, as we say, for a future time, inshallah, in terms of a discussion. But yeah, there are clearly many elements to this food chain that need to be heard from. So again, my apologies there. Sylvie, let me go back to you here. As you are aware, in our federation known as Canada. We have a distribution of jurisdictions between the provinces and the federal government. Many years ago, right, our Constitution and the separation of powers was drawn up in 1867, a few years before the Wright brothers, right? So we didn't see what to do with aviation. But the Supreme Court ruled in 1930, aviation, aeronautics, and matters related thereto are the purview of the federal parliament, right? That's never been changed. That's never been overturned by subsequent decisions. That said, I've seen a lot of proactivity, right, at the provincial level with a lot of these issues. The CTA and the CTA normally is responsible for enforcing the APPR as the federal entity empowered to do so. But we see a lot of people going to courts of common jurisdiction, provincial courts, to have their rights enforced and claim compensation, etc. Tell us a little bit about how that has been unfolding, including how some provincial agencies, such as the l'Office de la Protection du Consommateur in Quebec, among others, tell us how that has been working here. Is that a way forward here in terms of a joint jurisdictional approach with, let's call the CTA embattled here, right? In terms of all the complaints they're having to deal with and their limited resources. Tell us a little bit about how we can maybe look at that and maybe say, yeah, maybe it's time to change that sort of approach as far as consumer rights is concerned and not necessarily rely on the federal regulator.
Well, thank you, George, for this question. It's a very interesting one. Maybe I'll just take a little step back for those who are not maybe familiar with constitutional laws in Canada. So basically, and it's going to be very, very rough as a description, but some matters are within the federal jurisdiction, as you mentioned. Aeronautics is part of that. Banking, telecommunications are considered federal, while other matters are more provincial, such as civil law. And I specifically say that one because I believe it's the one that will be very relevant in this matter. And of course, when there's an overlap between those two jurisdictions, well, it leads to some judicial disputes, but that is again something else that will sometimes be up to the tribunal to mention. To answer your question, I think we have to take a look of a little decision that was rendered, not a little one, but it was, I think, over 100 pages, but another decision that was rendered by the Supreme Court of Canada in the Bank of Montreal against Marcotte case in 2014. Basically, this was a class action against banks regarding conversion fees in foreign currencies charged to credit card holders by bank. So it was alleged that those conversions were not correct, were violating, Quebec's Consumer Protection Act, and because they were not disclosed properly. Basically, banks argued that because they were federal, they did not have to abide by the Consumer Protection Act. So the Supreme Court declared that even though the main activity of banking was under federal jurisdiction, the contracts that they have with their clients does involve civil law. So in those situations, provincial law can apply. So then that which included the Consumer Protection Act. I think we can use this logic also when it comes to air traffic. The main, licenses and the air travel is clearly within the federal level, but when it comes to contracts between a merchant, which is such as an airline carrier, and a consumer, this can also be comes into the provincial jurisdiction when it comes to provincial laws. So that's I think one of the door that provincial organisms can use in order to help consumers on that level. I see Tom with your little smile. I think you may have some other things to say about that later on. That's okay. So with the delays before the CTA, I think some consumers may feel it might be quicker to go through small claims court when they have some issues with air passengers. When we take a look right now at the delays to file a claim and be heard before before any small claim course right now, I believe it is still almost as lengthy as before the CTA. So I'm not too sure people will gain time there. But we also have to take into consideration that the APPR does not necessarily cover all of the damages a consumer may when there's a disruption. So sometimes people may turn into civil laws instead of the APPR to have better compensation, depending on the situation. Of course, they have to prove their claim at at that level, and it's going to be up to the court. So, and when it comes to other parts of the law, such as publicity when it comes to pricing of tickets and things like that, we have laws also into provincial provincial legislation as well that can maybe apply. So I think both can work together. We do know, though, that according to constitutional law, federal has a first level of powers. So if, for example, there's some obligations in the federal law, the provincial law cannot go against those regulations and those obligations, but it doesn't keep provinces from maybe having more I would say severe laws in certain parts, as long as they keep into their civil law. So I think both can work in parallel, and at the end, it's going to be up to the consumers to decide which one serves better at the end.
Okay, well, thank you, Sylvie. That was a very detailed response. Tom, can I look to you for maybe a comment on that? Sylvie, after your job, how do you see a little bit of what Sylvie just said as the federal regulator in charge?
I don't think I had any specific comment on the different fora, George. I think, of course, consumers have the option of different fora to pursue their disputes with the airlines. I would mention that through the agency processes, for example, when I was talking about informal facilitation, we do have the facilitator who has that role of having that informal discussion with the airline and the passenger to air out the issues and dispute and to try to come to a resolution. The agency facilitator in that process is looking for the details of the event surrounding a flight and tries to make it clear what the entitlements of passengers would be in different scenarios. In facilitation, it is it's the agency facilitator who asks for information from the airline for that process. It's not the passenger who has to go to the airline for that process. So I would say that, our facilitators, when they sit down with the airline and the passenger to try to informally resolve a dispute, they do play an important role.
Okay. All right. Thank you for that. Let me go back to James. James, let's go back to E261. Let's go back to the quote unquote gold standard here. You mentioned some studies that were done in terms of what do customers want, what do consumers really want. Do they really want to pocket a check? Do they really want other things? But let's go back to the foundation of EU261 per se and the evolution of that regulatory framework. Because again, a lot of the discourse here has been, well, that's the solution, guys, and let's just cut and paste it over the APPR. But the EU itself has identified major shortcomings and issues with its own framework. We've seen attempts to amend it, all right, formally by the Commission, EU Commission in 2013, I believe, the package was published. That got caught up in an almost farcical dispute at the EU Council between the UK and Spain over jurisdiction jurisdictional issues over the Rock of Gibraltar, which is I had to try to explain to my CEO with a straight face, and of course he thought I was imbibing a bit too early in the day, but of course it's true. So those went nowhere. Take us through a little bit about what's happened in the EU over the last decade or so in terms of the evolution of 261, where it may or may not be heading, and why, again, it's not necessarily a panacea in terms of the Canadian situation.
Let's just get one thing out of the way. First off, I'm very attached to the Rock of Gibraltar. I got married on it, so it's very close to my heart. But obviously, that issue should have gone away with the UK leaving the European Union. A bit of British self-harm should have taken the Gibraltar issue off the table, at least in terms of the reform of EU 261. But other things seem to have gotten in the way. But I think you started your question by asking me to do some history, and you already did a little bit in your presentation. The original EU 261, the first thing to say is it had nothing about delay compensation in there, which you highlighted. It was really about denied boarding. That was the big issue that motivated the drafting of EU 261. And as so often happens in these cases, it was a personal episode that the commissioner at the time had gone through. Loyola de Palacio had a denied boarding incident, and said somebody must regulate about this. And oh, look at me, I'm the commissioner, so I'll do that. I mentioned denied boarding because if you look at the statistics that I quoted, and that 5.3 billion euro bill for 2018, of that only 600 million was related to denied boarding. That's not the big issue. The big issue now is, of course, delay compensation, and that only came in through Sturgeon, which Sturgeon is a case of the European Court of Justice. I'm not a lawyer, but lots of lawyers that I speak to about 261 say it's actually a really quite badly drafted piece of legislation with big, wide open gaps for interpretation, and those gaps have been filled by the European Court of Justice. And so the law has really been, and the gold standard that you refer to is really the way that the judges of the Court of Justice have interpreted what was a reasonably poorly drafted piece of legislation back in 2004. And I think that it's partly that creates some of the many challenges that we're now facing. In terms of some of the specifics, I think that are really important in terms of a revision, and that were on the table in 2013, and again came back under the Croatian presidency in 2020. One is the delay thresholds, and again, I come to the point that the delay thresholds that were set out in the original regulation were all about care and assistance and rerouting. They weren't about compensation. It was only when Sturgeon made the ruling that a long delay equated to a cancellation that then delay compensation was payable. But a long delay of 2 or 3 hours was not what was necessarily meant as a de facto equivalent to a cancellation. So the 2013 proposal proposed keeping the delay compensation, but extending those thresholds to more long delays depending on the distance of flight. And that would give clarity to the consumers and give effect to what the judges had opined on in the Sturgeon case, but at a much lower cost to the carriers. The second key element was around this issue of who was in control, and what in EU 261 language is called the discussion around extraordinary circumstances. And this became very relevant for things like the volcano and so on. And so what as an industry, what was proposed and what as an industry we supported was creation of a list. A binding but non-exhaustive list. Binding because everybody knew that if something was on the list and that was an extraordinary circumstance. Non-exhaustive because you'd never think of everything. There's always the black swan, to use that hackneyed phrase, of something like an Icelandic volcano or COVID. And so again, that was an innovation that we thought would provide increased certainty, improve the regulation from how it was originally drafted, and actually make some of the application much easier. And I could go on, but I've already gone on long enough. There are lots of things like this and there continue to be decisions on a very regular basis from the Court of Justice that continue to interpret and reinterpret the regulation. So it's, and I think that in itself, the fact that those questions continue to arise, supports the argument that it's very far from the gold standard. Thanks, George.
Okay, thank you, James. Sylvie, you are one of the persons who was quoted as referring to the EU 261 as a gold standard. Can I ask for some of your thoughts and comments relative to Jared's input on that?
Well, I'm not a specialist in European law, so that I have to admit. I'm not saying necessarily that we have to copy paste this legislation, but to me, and as I said in the opening comments, the level of liability that stands on for safety purposes, I believe is way too broad, and that specific one does not exist in the European legislation. Basically, you have what is within the airline's control and what goes beyond their control and cannot be taken care into in regular circumstances. So I believe is it does not provide. I think on that level it provides a little bit more clarity, because the problem is, of course, there's a definition of what is a safety purposes in the law, but let's face it, consumers do not read the law. We cannot expect them to read and to understand the law, and not even the airline's tariff when it comes to documents that are sometimes over 50 pages and are not necessarily in a language that is clear to people who are not lawyers. We cannot expect people to read those documents and understand them and compare them with one another. So for me, if something is clear and people know what they're entitled to, there will be less contestations on either side, because we all know what all know what the rules are if the rules are clear. And when people know that they don't have any rights to claim, they don't claim for nothing. So, and sometimes that's basically what the rules are. So, but when something is, in a gray zone, and that it seems to be the case when it comes to safety purposes, that can lead to complaints that sometimes are good, sometimes are wrong. I'm not saying all the consumers are filing complaints are always right, but at least when it's clearer for everybody.
Okay. Thank you, Sylvie. Okay, just before going to our next question, I just want to say, for the benefit of everybody attending, I see in the chat there are some questions which are directed at me for response personally. Let me remind our dear attendees and ladies and gentlemen, I'm here to facilitate a discussion. Please, I'm not here to answer questions. I'm here to facilitate. We have very distinguished guests and panelists for that, and I would ask you to direct your questions specifically to one or more of those people, those of the panelists. So thank you, just as an information for all. Jared, let me go back to you here. We haven't forgotten it yet. Safety, the safety exemption issue, right? This is one where, as you know, I was personally involved when the APPRs were being put together. And as you know, this is something which the aviation industry has said was important to ensure that we don't allow consumer protection mandates to inadvertently undermine flight public safety mandates. And I always say inadvertent. Nobody starts out by saying we want to reduce or undermine flight safety. So with that in mind, again, we've had the complaints here about airlines in Canada saying, well, this is a flight safety issue, and this is one, and this is one, so we're not paying compensation. I don't want you to necessarily comment on any particular case. Tom has already mentioned the issue about crews, right, and crew availability that I believe is currently in front of the federal court. So again, we won't touch that. But Jared, help our audience here, help us understand a little bit. How could we perhaps respond? How can the industry perhaps respond to some of those complaints, right? In terms of, well, you're just hiding behind this, guys, to avoid paying legitimate compensation. Because in the end, are we not potentially, right? Be careful what you wish for, right? Because in the end, we might even see an amendment that removes the exemption altogether and harmonizes a little bit more with Europe. How do we perhaps provide more ability for the airlines to provide clarity to their customers? Maybe the CTA address the issue. Do we need to amend the definitions in the APPR? I'm sorry, this is a lot of stuff I'm putting on your plate, Jared, but I know you're a very capable guy, and I know you're right at the forefront of this in the industry. But again, it is a problem. It is a bugaboo for a lot of folks, and they're saying that that's a get out of jail free card. What do we do? What does the industry do to try to allay that? And also address the issue about how we're supposed to say if it's safety or not if we don't have right access to the information the carriers have about the reasons and the technical issues and all that. Go ahead.
Yeah, thanks, George. I apologize that you're getting questions in your now retired stage on this, but again, you've settled well into your academic role. Listen, I think safety is a really, really complicated issue, and that we've seen over the last little while. It's worth a reminder that, although these regulations came into place in 2020 or late 2019, 2022 really is the first year of full operational, of kind of a full operational year where we've encountered the APPRs, the interaction with them, the interpretation, new decisions. It's been a full kind of couple years as we've all kind of settled into this. I think that anybody who expects that a regulation will be clear and will come out perfectly out the wash immediately is expecting a little bit too much. The intention of what the safety related element that was put in again is to ensure that safety remains sacred in the sense that nobody's taking shortcuts for safety when it comes to potential costs or looking at it from a profit perspective. And when we go back to what James said in terms of $10 US in terms of post-tax profit for airlines in the glory days of 2019, that's even significant, and that's not something that we've ever seen in Canada. But you get the idea of how little there is in terms of profit margins in this sector. So when we're talking about significant compensation amounts, we never want to see a situation where safety becomes entangled in a regulatory regime that might cost an airline. I think that there's an opportunity, and I think that we're starting to see it through certain decisions and through better interpretive capability on what safety is. And I think that we would be open to creating a more robust list of what a safety incident actually is. In terms of how we can do better as an airline or as an industry in terms of being more clear to our guests, I think that comes down to the communication. A flight and the interconnectedness of aviation is really not subject to just that flight that a passenger is traveling on. So somebody might be delayed from Calgary to Vancouver, and that might be a delay that goes all the way back on a root cause basis for a day and a half. When I talk about some of the flight duty regulations, especially when we have compounding weather or if we have irregular operations in one of the major airports, that breaks the entire system in Canada. So if you have a fundamental irregular operation that has significant delays or significant cancellations in any one of Calgary, Vancouver, Toronto, or Montreal, you can suspect that the entire system across the country will have impacts that carry on for at least the remainder of the day. It may seem strange to a passenger that something that is disruptive in Vancouver impacts their flight in Regina, or some terrible weather event that's occurring in Toronto will impact their flight in Fort McMurray. But that's unfortunately the way that this industry operates. And one aircraft does not only operate in one single jurisdiction, it will operate across the country, it'll operate across multiple jurisdictions. And the impacts of any one incident are really what results in some of these challenges. So when we're talking about delays or impacts on one flight and safety related issues, it could be the result of crew rest from the previous day that's the result of a mechanical issue or the result of a weather issue. And I think what we need to be able to do better in order to be able to help support passengers and their understanding of this is be a little bit more clear in our communication and how we relay that. The challenge comes down to the complexity or the simplicity of it. How much do we communicate? What is over communication? What is under communication? Is it helpful for us to tell people that a plane has gone mechanical and is having an engine issue prior to flight? Is that too much information where all of a sudden people have concerns about the safety of traveling? And how much detail should we add for individual events that might be compounded or impacted by something that after previously occurred to that crew? So those are some of the things that we're certainly working on to see how we can improve. The intention is not to mislead anybody or any passenger. And I think that we've seen through decisions by the CTA that no carrier is doing that. There is no malfeasance. There is no intention of an air carrier to skirt their obligations. And that was conveyed in terms of the on-site investigation that was done back in 2021 related to air carrier coding. So now it just becomes an issue of actually how we convey that and how we get that information out to passengers in a clearer manner to make sure that they understand. And perhaps it's something that we need to work with the CTA on how we actually more clearly define what a safety incident is and how it pertains to their travel.
Well, thanks for that detailed response, Jared. I appreciate that. And I hope the fine folks at Transport Canada Air Policy are going to be obviously advising the minister as to what sort of things need to be perhaps done. Nip and tuck of the current framework. We're maybe hopefully listening and taking notes. But before I go on here, I'm going to turn to Tom now with respect to that and what may be coming down the pipe or not. Sylvie, reaction, consumers, big bugaboo. Safety, no compensation. What do you think of what Jared has proposed here? How do you think that would fly?
Well, surprisingly, I do agree with part of what Jared said when it comes to communication. And we know when there's a disruption, it literally causes chaos in lots of situations. And the problem is that a lot of time, even the staff members on the floor at the airports are sometimes as overwhelmed as the passengers. So it's very difficult for people to get the appropriate information. And that's the lack of information. And I'm not saying necessarily that airlines have bad intentions of that. And I know they are probably putting more focus on trying to get things right before also having to communicate with people. But a lack of communication does cause a lot of stress, and people are stranded in airports, don't know where they're going to leave. Sometimes people have very good reasons to travel. There are people who are traveling for fun, but some people have very important meetings or important family situations that they have to take care of. So it causes a lot of stress as well. So I think communication really is probably the key, and being sure to know what's going on, and of course we don't have any crystal balls. We don't necessarily how long will the disruption last, but with regular updates and what really caused the disruption, I think is something important. From what I've seen, sometimes people were complaining that they said, the airline simply said safety issue without anything to base things on. So that is not sufficient, and that is clearly not sufficient to decide whether or not to file a claim, to file anything. And the problem there also is that most of the passengers' right depends on the information that they gather from the airline companies. So if some companies just provide very laconic type of information, they don't have any information for what is going on, what are their rights, and that is something that should be working. Lots of air companies should be working on, I think.
Great. Thank you very much for that, Sylvie. Tom, can I turn to you now? Just going back to what we were referring to earlier about the minister and his announcements the last couple of weeks, including to the Parliamentary Committee on Transport last week. changes will come, resulting as a result of a lot of the problems that we've witnessed last little while. I know you are, of course, a very good public servant, and that you can't go into any detail right now as to what is being discussed confidentially in government, and perhaps in cooperation with you, as obviously the regulator will have to enforce and act. But can you at least share with us whatever you can about what you think may or may not be coming, and more specifically, a little bit, and this is for the benefit of a lot of people who may or may not be aware, the process involved, the timelines involved with these sorts of amendments, that sort of thing. Again, in Canada, for those of us who are not as intimately familiar, Tom, you, the regulator, are not the one who basically will push forward on the direction here in terms of a lot of what's coming down the pipe, but you will be the one helping to write and eventually enforce, and that is the Minister of Transport who makes those decisions. So I want to make that clear in terms of the division of responsibilities. But Tom, please take us a little bit through going to unfold, and again, maybe some of the timelines to see when we can expect to see, something.
Thanks, George. George, I'm not really in a position to speculate on details and timelines, but I mean, just a reminder of where we are. So before 2019, airline tariffs essentially determined what passenger entitlements were during flight disruptions. So there were airline tariffs, there were agency decisions on specific complaints with respect to those tariffs. That was before 2019. That was the main force shaping what the dynamic between passengers and airlines and consumer protection. Since 2019, what's changed is we now have common regulatory requirements for all airlines. The minister, in his comments, I think last week, spoke about simplifying, clarifying, and strengthening the air passenger consumer protection framework. It's interesting that the House of Commons Transportation Committee is conducting a study of the APPR. Agency officials, Transport Canada officials, airlines, industry associations, consumer advocates have appeared before the House of Commons Transportation Committee or made submissions. And I think it'll be, of course, important to read the report of the committee and the recommendations that it makes regarding consumer protection for air passengers. The agency, as I mentioned earlier, is an independent arm's length tribunal and regulator, and we would, of course, implement any revised legislative framework that is approved by Parliament. I'll also add that the chair and CEO of the Canadian Transportation Agency stated at an appearance before the House Transportation Committee last week that she felt that there is some lack of clarity generated by the three categories of flight disruptions, that it made it difficult for passengers to know what they are entitled to and for airlines to know what their obligations are. Thank you.
Okay, that's helpful. Okay, I'm just looking here a little bit on the online chat. If not, let me turn back to James. James, again, we're in Canada. Let's get back onto the nice airplane and fly off somewhere to a nice locale or destination. Take us back again to a little bit about what's transpired in the last year when, again, winter in Canada is legendary for the troubles it creates for the system and all that sort of stuff. We can't stop Mother Nature snowing, and snow in Vancouver is always a red letter event, right? And as we saw, however, let's go back to last summer. Let's go back to systemic issues all around the world, right? Again, we want to remind everybody, Canada wasn't unique. Yes, Montreal and Toronto had a very poor on-time performance record among world airports. We can't deny that, we won't, but it wasn't unique. Tell us a little bit, James, about how things transpired, especially last summer, around some parts of the world you're more familiar with. Again, how have the relevant consumer protection laws in those jurisdictions, how they've handled things, right? As opposed to a lot of the complaints and problems and headlines we've seen here in Canada.
Well, I think I've got no particularly good news. I would say, if I look around the world, I would say, apart from maybe a sense that what you suffered in Canada was not by no means unique. Certainly in this part of the world, in Europe, there was significant disruption at certain parts of the network. But let's just go back maybe to what we were dealing with, and we've touched on it at various points in the discussion. But we had a system that was pretty much shut down for 18 months to 2 years, largely by government mandate, in the interests or in the name of protecting public health. But you talked about the losses that were sustained, but also the extent to which this hugely complex system was largely shut down, or at least scaled right back. And then very happily, the start of or the sort of middle part of last year, the borders really reopened very quickly, restrictions were dropped very quickly, and sort of trying to ramp up something that had been scaled right back for that period of time. And that's an experiment that's never been tried before in peacetime, and I hope it's one that won't be repeated in peacetime. But I mean, it comes to that complexity of the network you talked about, and the global network. And we've talked a lot about Canada. I'm just going to go off a slight tangent for a few seconds. It's a global network that really runs best when it's global rules, a single set of global rules, so that essentially what you're dealing with in Canada, in Europe, in the US, and in other parts of the world. And the pandemic was the exact opposite. We had huge fragmentation. And actually we're heading there. I make the point because we're heading there in consumer protection as well, globally. And it's one of the challenges that we haven't talked about, is the patchwork of different consumer protection regulations. But nobody was really immune. Trying to ramp up, and there were bottlenecks. Sometimes that was very painful. Schiphol in Amsterdam would probably be the most amongst them. And in terms of the challenges of responding to it, I don't think any of none of the regulations have responded well yet. In terms of some of the activity by regulators, very similar. Those challenges were across the value chain, and we haven't seen this issue of accountability and responsibility across the value chain being addressed. There've been some, what I would say, PR statements, and Schiphol Airport dipped its toe in that water and said, well, we will pay something. First, they said they would pay something direct to the consumer, but the airline would still have to handle refunds and compensation payments. Then they said, well, we'll actually pay the airlines to cancel flights. But that's a single scenario. What I would say is there isn't a best practice I think we can look at how that was handled. But it was also a point in time. I think it was the other point I would make. And let us all hope that level of disruption is something we won't see again. And I think it's a sincere hope that from all in the industry, from the consumer side, we want traveling to get back to how it should be. And I think we all have a common interest in that. So I think no great examples, I'm afraid, George, but yeah, I think context also required. Thanks.
Great. Thank you very much, James. Okay, folks, I have 6 minutes to 12 Eastern time here in Montreal. As you know, we're scheduled to run till 12 noon. We will definitely arrive on time, right? Sylvia, I hope will be proud of us for that. But before we end our deliberations today, I would like to put out a last call. If anybody would like to have one last quick comment about a few of the things and a few other love to see in the next few weeks or few months about what's coming down the pipe. Can I just do a quick one, Sylvie, just to finish off? Anything else you want to add?
Well, I do have one thing, but I'm afraid that it will maybe trigger another kind of situation. But one of the things that I am concerned about is overbooking. That is something that is very stressful for consumers. And as a consumer side, I believe this kind of practice should really be abandoned. It's not something that should be allowed because basically when we have a contract, people expect a contract with a for travel is for a company to travel us from point A to point B, and people are rightfully expect that this can be done. And when, for example, there are 300 places in a plane, I don't think that we should sell more than 300 places, and so people don't have to win the lottery of who's getting on a plane if the algorithm goes wrong. So that is something I think should be readdressed in the regulation. I think I'm jumping a bomb here, but that is something I think we can also take a look at further on.
Great. Thank you, Sylvie. Jared, big smile. Anything else you want to add?
Yeah, I was just, overbooking is obviously a common practice amongst the industry, given significant amounts of individuals who cancel at the last minute, all the rest of it. Just very speaking on behalf of WestJet, in 27 years, we've never, ever undertaken the process of overbooking. So we always only sell to our capacity and our capacity only. The one other thing, George, that I just want to touch on this is there's been some speculation and discussion around fines and the levying of fines, and I want to create some inaccuracies and some false information that has been spread as it pertains to this. And there's been some information spread by individuals in the media that airlines tend or attempt to skirt their obligations by awaiting the administrative process of the CTA, and that paying a fine is actually beneficial to an air carrier because it is lower than the amount of compensation paid. And that is entirely factually incorrect. And I'd just like to highlight and clear that here. Any fines that are actually issued by the CTA do not change our obligations to pay. So, for example, there was a fine that the CTA levied upon us as WestJet earlier this year for about $11,000. For a number of individuals that we did not meet our requirements under 19.4 to respond within 30 days to. There are assertions made that we took that fine and did not have to pay the compensation, and that is entirely incorrect. Those are cases where we did not pay compensation within the allotted 30 days, or we did not respond to them with a reason within 30 days. So compensation was due and the fines are still payable. It does not change that. It is not in our interest to accept fines. That is an additional liability. And again, we remain very committed to our obligations under the regulations, and we seek to meet our obligations to the best we can and avert fines. But this isn't a matter of one or the other. We're unfortunately susceptible to both. So just a point of clarification and a last remark from me, George. Thank you for today.
Thank you, Jared. And we are looking forward to your appointment as the new Vice President of Communications at WestJet. That's very well done. Thanks, Jared. James, a quickie, anything you want to add?
Two things very quickly. To Sylvie's point on overbooking, I mean, as I said, that was where EU 261 started. And the other thing is in the US data, US has got very good data on this and involuntary denied boarding. So the situation where it can't be resolved amicably is a vanishingly small problem. So, I think we just need some perspective on that. Hear the point for further discussion. And to Tom and the CTA and the sort of the government and regulatory point, just reiterate this thing about focus on things that actually incentivize improved performance. We have a common shared interest in that. And I think that's where the magic is. And I don't think it's what the APPR is doing right now. Thanks.
Great. Tom, last word goes to you. The man on the hot seat. Has it cooled off a little bit over the last 2 hours? Anything you want to add on this?
George, thank you. I will say that, the agency is certainly not where we want to be with this backlog of complaints. We know that, it's a frustrating situation for those who have complaints into our system. all complaints will be handled as fast as we can get to them. I would urge people to take a look at our website. We've tried to put as much information in as easy to follow format as we can. The case status update is a great tool for a complainant to know where they are in the queue and what the next steps are in their case. I know it's frustrating to be at the end of the queue, but every month a complainant will see themselves move up the queue, and hopefully that is helpful. And also, as I said, we've got lots of information tools available on our website. We're trying to put more stuff on our website all the time.
Great. Thank you very much, Tom. I have noon exactly Eastern Standard Time. We are at the end of our discussion. Thank you very much, panelists, for an excellent discussion. Folks, I am a big believer in the fact that in our liberal Western democracies, we have a lot of different varying stakeholder interests, very legitimate ones, and that public policy is a zero-sum game, folks. It can't be I win, you lose. It's got to be some sort of thing in the middle that achieves some sort of reasonable balance. I hope today we've helped that process along a little bit in terms of our little academic discussion. So thank you very much again to our panelists. Thank you to our attendees for joining us today. I certainly hope you found something to be of a little bit of interest in your daily lives here. And of course, thank you to McGill, to Stefan Michael, especially for having provided us critical administrative support. And of course, to Professor Hanley as interim director of the Institute for welcoming us today to the ISL's webinar series. So folks, stand by, keep looking at the ISL's site there on LinkedIn for future webinars. There are going to be a lot of them coming, and we hope to see you again soon. So my best wishes to all, and thank you again. Take care.
Thanks, George. Thanks, everyone.